Good morning. The joint meeting of the Leeward and Windward Planning Commissions will now come to order. It is Friday, June 2nd, 2023. The time is 9:07 a.m. This meeting is being streamed live on YouTube. The Leeward Commissioners are attending via Zoom. To comply with the Sunshine Law, when your name is called, please state who else is in your location and if they have any interest in this matter before us today. So I'll introduce the Leeward Commissioners first. Chair Barbara DeFranco.
Aloha, good morning.
And Chair, do you have anybody in your location?
No, I'm in a private room.
Thank you. Commissioner Mahina Paishan Duarte.
Good morning, President. I have no one with me.
Thank you. Commissioner Clement Kanuha III is absent and excused. And the following Leeward Commissioners are also excused today. Vice Chair Zahiva Knowles, Commissioner Mike Dela Cruz, and Commissioner Mike Vitusik. Here in the Hilo Council Chambers, I have myself, Chair Dennis Lin, Vice Chair Louis Daniele III, Commissioner Lauren Baylog, Commissioner John Cross, Commissioner Wayne DeLuz, and Commissioner Chantel Perrin. And we do have a quorum to hold this meeting today. I will be chairing right now, but it is up to the commissioners to decide who will be running the meeting today. Leeward Commissioners, please be reminded to please remember to keep your camera on, as the Sunshine Law requires at least a quorum to be visible at all times. I will now introduce the Office of the Corporation Counsel. Deputy Corporation Counsel Sinclair Salas Ferguson, attorney for the Planning Commissions.
Good morning.
Deputy Corporation Counsel Gene Campbell, attorney for Planning Department. Representing the Planning Department, Planning Director Zendo Kern.
Aloha, good morning.
And we have the following staff here in person: Planning Program Manager Maya Jackson, Planner Tracy Lee Camaro, Planner Clinton Mercado, Windward Secretary Melissa Dakayanan Salvador, and staff via Zoom, we have Leeward Secretary Noriko Sauer and a Zoom host, Janice Hata. A bit of housekeeping. In-person attendees, please keep your cell phones turned off or on silent mode. Zoom attendees, please silence your other devices. To everyone, please speak directly into your microphone and mute it when you are not speaking. Only one person may speak at a time, so please raise your hand to be recognized by the chair before you start speaking. All commissioners, it's difficult for others on Zoom to see who is talking, so please identify yourself before you speak. And if there's anybody in the audience that would like to testify, please fill out the yellow form at the staff table and give it to the staff. If you have provided written testimony that has not been sent in earlier, you may submit that to the staff at this time. This is also a remote meeting, so according to the Sunshine Law, if our audio-visual connection is lost, the meeting will automatically recess. And if the connection is not restored within 30 minutes, there is no quorum, the meeting will be terminated. Finally, we do have the regular Windward Planning Commission at 11 o'clock, so we'd like to finish this meeting by then. Before we move on to public testimony, I would like to take a 10-minute recess for commissioners to review the last-minute testimony that's been received this morning. And I want to confirm with the Leeward commissioners, have you received the additional testimony?
Yes.
Okay. So with that, we'll take a 10-minute recess for commissioners to review. We'll come back at 9:22. Thank you.
Can anyone hear me?
Okay, calling the joint planning commission hearing back to order. We do have to decide on the chair that will be running the joint meeting today. So just to explain a little bit, whenever the joint Leeward and Windward Planning Commissions convene, the chairperson for that meeting shall be either the chairperson of the Leeward or the chairperson of the Windward Planning Commission, selected at the time by affirmative vote of a majority of the combined membership of the two commissions. The chairperson not selected as the chairperson for the joint meeting shall serve as the vice chairperson for the joint meeting. So right now I need a motion on the floor for who will be the chairperson for this joint meeting.
Nominate Dennis Slim, chairperson.
I'll second that.
Okay, motion by Commissioner Deleuze and seconded by Vice Chair Daniele. Is there any discussion on this motion? Okay, if not, do we need to do a roll call or just affirmative? Okay, all in favor, please say aye.
Aye.
I
Aye.
Any opposed? Okay. I will serve as the chair of this joint planning commission meeting, and Chair DeFranco will be the vice chair for this joint meeting. Thank you. So we will now move on to public testimony. Okay. Before we start, I'd like to mention to everybody that we may limit testimony that may be irrelevant, abusive, disruptive, or unduly repetitious. The person testifying shall direct your remarks to me as the chair and not to any individual commission member, staff member, or person in the audience, unless directed otherwise. All members of the public shall extend the proper courtesy and respect to one another. And any person who does not abide by these rules, I can, cut you off and we will go on to the next person. So I please ask that all the commissioners and the staff assist with that and the testifiers. Okay, so starting with any in-person testifiers, I don't see anybody here in the Hilo chambers. So if not, I will move to Zoom testifiers. So Janice, can I please start with the first Zoom testifier?
Yes, good morning, Chair. Our first testifier is Simi McMichael. Simi, if you could unmute and turn your camera on, and you have 3 minutes.
Okay, can you hear me?
Yes.
Aloha, my name is Simi McMichael of Kailua Kona. I find this bill that you're presenting here totally overwhelming. This is so much detail. Back in 2010, I attended the DLNR state public hearing on all these matters when all these rules are changed. This is too much. I submitted 15 pages of a lot of photos of how Ali'i Drive, the sea level has already risen. And with this presentation today, it is giving the planning department and director the authority when it should be public. This is a whole issue of the shoreline and the historical preservation of it. And like page 52, the director may waive certified shoreline survey and considerable distance. What is considerable distance? When you get the SMA minor permit and major permit, it clarifies is the minor but it gives the planning authority to distinguish the major. The major is 500,000 plus. And it conflicts with the structure of 7,500 square feet. But it's a lot of like 77, you waive public hearing. This is a public issue. It should be sunshine law, especially of our beaches. And since 1986, with West Hawaii Surfing Association, I have been forefront on our seawalls in our main surfing spots. This is Bahipana. This is our cultural natural resources of surfing. All these structures on the ocean front are going to go down. And to allow the planning department and not the county council to make these crucial decisions is wrong. And the average person doesn't understand. And this is making it complicated for me also. So I would please like you to do what you're supposed to do and take it to a public workshop so that all of us can understand how this will affect us moving along in the future. And when I contested cases, you can
30
see clearly,
seconds.
you can see clearly that they wanted to use the 20 feet. You know, it's 40 feet now. And in my testimony, I showed you that the other islands have moved to 60 to 130. Look at the North Shore. That's surfing. What is allowed? You're allowed not to put your sandbags, not to put your seawalls, not to take away our beaches. You're allowed to take your structures and move on. So I'm saying surfing is our Bahipana. We need to take back our beaches. We need to open space along Ali'i Drive. The pictures say 1,000 words. The cesspool at Kahalu, the 2007.
Sorry, Simi, your time is up.
Okay, mahalo.
Thank you for your testimony. Commissioners, you have any questions for this testifier? If not, Janice, sorry, I missed a step here. I do need to swear in all the Zoom testifiers. So if possible, are the Zoom testifiers able to turn on their cameras?
No, I'm not. I can't turn on my camera, but this is Claire, but
Okay, if you can't turn on your camera, that's fine. Oh, we still have to go through the
yeah. Okay.
Yeah.
And if you can, sorry, I know there's probably a lot of people that want to testify, but you know, I think you all know I'm a midwife. I need to leave to a birth real soon. So I'd like to be towards the top if I could. Thanks.
Okay, thank you. So Zoom testifiers, I'm just gonna, if I can't see anybody's camera on right now, but do you swear or affirm to tell the truth on this matter now before the Joint Planning Commissions? And before you speak on the when you testify, please state your name and the area you reside in. And we do want to state that you have 3 minutes for testimony. Thank you. So Janice, you could move on to the next testifier.
Okay, Claire, you can begin your testimony. You have 3 minutes.
Aloha. Noho honaka mauka. I'm on the Elias Kona. I would second everything that Simi said, but I want to read something to you because we're working, and this comes from Reckman in 2000, Reckman and Kamara in 2007. And it concerns the lots 13 or 19 or Peikoa Ka'aina Pehu. And so it's really important. I actually had a number of photos that I wanted to send you, the before and after, before permits were given out. Nothing was ever permitted. The archaeological study has never been done. It's really shameful. The archaeological well, the cave, that's most likely a branch of the Ohia cave where there's burials in there, is now got a house over it, all done illegally. So it's really needs to get back into the process of what you guys are supposed to do, what every department is supposed to do to before someone is able to build, no matter how wealthy they are and how many 5 other places this person is doing and building, and then he's going to sell it for $1 million and move on, or whatever the price is. So I'll read this paragraph. This comes from that survey. Several special archaeological preservation areas occur within the Kahalua Historical District. These sites include, but are not limited to, heiaus, burial sites, trails, and refuge habitational caves. The district contains no more than 12 heiaus. Ke'umanu, Ohia Mukumuku heiaus are located nearest to the current study parcel, which is 19 and 13. Another site of interest on the south of the project is Ohia Cave. This Makai portion of the cave is subject to investigation, consisting of a main tube. We have photos of that main tube. It's really, really sad that it's been just devastated, and the archaeological well. That tube is 1,650 feet, Malka Makai, with short branches going north and south, and
30
human
seconds remaining.
burial clusters representing a minimum of individuals between, there's thousands buried in there, but Ohia Cave has several entrances in the confines of Kalu district. We have to do better. We really need to do better. This is a lineal descendant I will be helping birth in today. Now, this has a deep effect on us. It is an emotional thing that the Leeward and the Windward districts need to understand, that relationship between what's what's
I'm
sacred.
sorry, Claire, your
our-
time is up.
It's sacred, the land and the humans, and especially this baby today. Amamo'ono, mahos.
Thank you for your testimony. Is there any questions for this testifier? If not, thank you very much, and we'll move on to the next Zoom testifier.
Yes, our next testifier is Maki Morinoi.
Hello, aloha, Windward and Leeward Planning Commission. Thank you for this opportunity. My name is Maki Morinoi from Holualoa. Today I'm representing Hulipak, which is an organization with members all around our moku of our Hawaii Island. I concur with what Simi McMichaels and Claire has mentioned, particularly around preservation and the allowance to have our planning department to have authority over preservation lands. It was very difficult to kind of understand. It was a lot of description, but not enough detail for me to understand what certain, it was too open-ended. So therefore it creates a lot of possible loopholes. So for those reasons, I'm asking you today to oppose Agenda 1 for the shoreline setback. Also concur with other islands going to 60 to 130 feet setback. But primarily, I think it's how we cultivate a cohesive agreement around the island, and including being more inclusive to our island residents and giving authority to county council, and really creating and having a conversation around offshore setback and what that looks like in conjunction to preservation. So therefore, I believe this is not ready yet. There's a lot of loaded questions and red flags for us. So we strongly oppose this today. Mahalo for your time.
Thank you for your testimony. Any questions for this testifier? If not, we'll move on to the next one.
Our next testifier is Corey Harden.
Yeah, good morning, Commissioners. Corey Harden from Hilo. Thank you for your volunteer service. I first want to say I'm very concerned about what I'm hearing from the other testifiers. I hope you take it to heart. First, regarding public notice, I only found out about this meeting because a friend told me. My email notices suddenly stopped coming and no one's been able to fix the problem. Then the boards and commissions web pages did not show this meeting till after I asked that it be included. Now it is. On shoreline setbacks, I hope you're looking at what the other islands are doing. I did not attempt to do a thorough study of all the different island rules. They're incredibly complex, but I did notice that they use erosion-based formulas, all the other islands, and Oahu and Kauai have some provision for a 60-foot setback. For archaeological resources, I support the most protective measures, which seem to be an archaeological inventory report or a no-effect letter from DLNR. You never know where you might find cultural resources, just based on my own limited personal experience. When I was 10 years old, which was a long time ago, I was digging in the sand at the beach at Waipio and I dug up a skull. And my mother looked very shocked and she said, well, just cover it up, which I did. I have no idea what happened to it. And several years later, my sister went on an archaeological trip to Kalai, and the person in charge told her to go into a burial cave and take some bones out, which she did, gave them to the person in charge, and she doesn't know what happened to them. I've been told there's burial caves in the impact area of Pohakaloa. No one has ever really checked. The Army just keeps bombing. They will not go in to check. And as everyone knows, there's many significant artifacts probably destroyed before there were any laws passed, and still many troublesome things going on to this day. Let's see, and on the rebuild rules, it looks like you could do multiple projects costing just under the 50% cost of replacement.
30
And so-
seconds remaining.
Rebuilding, but you could avoid oversight. Okay, thank you for your service.
Thank you for your testimony. Is there any questions for this testifier? Seeing none, we'll move to the next testifier.
Our last testifier is Antu Harvey.
Aloha, Chair DeFranco and Len and members of the Lord and Windward Planning Commissions. My name is Antu Harvey and I live in Holualoa. I am testifying on my own behalf. I am also the Executive Director of Pulama Iokona Heritage Council and have submitted written approved testimony on behalf of the Board of Directors, but I'm testifying on my own behalf right now. I oppose the changes to the Planning Commission Rules 8 and 9 as read. I concur with the other testimony given this morning. My concerns particularly are on number 8 is that the shoreline setback is just to the new minimum to match Act 16's amendment. But as it's been said before, the Maui and Oahu are moving actually back to like 60 or 130 feet, and our own county planning department planning for a sustainable future that's been out for comment even says that the estimates have been underestimated. So we should actually be moving forward, receding back a greater amount for protection. I'm also concerned about number 9, in particular with the historic archaeological for the SMA procedures. This shouldn't even be on the table. Act 16 didn't make any changes to these HRS rules. So this should not be even included. And if it needs to be addressed, it should be addressed separately and go through proper process, and the protection should be more effective, more streamlined, but not cut corners. It should be actually more thorough. And in our other testimony with Pulama, we've talked about the use of the CRC and proper due diligence and community involvement and all. That planning document that's out for review speaks very nobly about better community involvement, especially with people that understand the Wahipana. And so I think that that's really important in these matters. And the county needs to build trust with the community and to be really involved. And right now it's feeling more like trying to streamline things to make things go faster for development and not good protections for our community. So thank you very much for this opportunity to testify and for your dedicated service. Aloha.
Thank you for your testimony. Any questions for this testifier? If not, testifiers, you may continue watching the Zoom link on YouTube, the live stream. We'll now move on to the unfinished business, which is agenda item number 1. Proposed amendments to the Planning Commission Rule 8 and 9, review and action of proposed amendments to County of Hawaii's Planning Commission Rule 8 regarding the shoreline setback and Rule 9 regarding the Special Management Area SMA to conform with Act 16, which amended Chapter 205A Hawaii Revised Statutes regarding the Special Management Area and shoreline setbacks. The proposed amendments to PC Rule 8 and 9 seek to add sea level rise to the definition of coastal hazards, adds a definition of beach to enhance beach protection, restricts construction of shoreline hardening structures at sites with beaches, increases the minimum shoreline setback from 20 feet to 40 feet, and includes the construction of a single family residence on a shoreline parcel as development, and changes SMA application requirements related to historical resources. So first up, we'll move to staff presentation by Tracy.
Thank you, Chair. Please hold while we get the slides up. Good morning, Chair and members of the Windward and Leeward Planning Commission. Before you today, we have the review and action of the proposed amendments to the Planning Commission Rule 8 and 9 regarding the Special Management Area and Shoreline Setback Area. As you all recall, we did meet on April 20th, 2023, and the proposed changes are going to be presented to you today based off of that meeting. First off, I wanted to discuss one of the proposed amendments that was discussed at the past Joint Planning Commission meeting. And I really want to kind of discuss this because before I go into the proposed amendments, I want to be able to address Commissioner Paishon Duarte along with Commissioner Kanuha's request for opinions on Kuleana lands and whether they could be exempt from SMA review. So staff worked to see how we could incorporate this into our current processes, while also looking into the current legislative bills and see where our authority can really land with this. We're still in the process of looking further into this. I did provide to you guys today Legislative Bill HB 365, which was passed out to the commissioners this morning. And this does address some of the Hawaiian customary practices. There is still more work, like I said, that needs to be done on the legislative side that would need to be done in regards to the Kuleana lands. This bill was currently put onto the governor's desk at the end of April, so we will be waiting for that to get passed. You will not be voting on this bill today. It is just merely informational, and this will be our next steps with the rule amendment should this bill get passed. My apologies. This went right back to the beginning of the slides.
Excuse me, Tracy, can I just jump in for a minute? So for the public's sake, I just want to read off what HB 365 is proposing. It's proposing to exempt from SMA review any practices. It says traditional agricultural practices or traditional fish ponds. So any work within traditional fish ponds would be exempt from SMA review. The other provision that it provides is an exemption for SMA review for Hawaiian traditional and customary practices, including work conducted by traditional means near, in, or related to loko'ia traditional Hawaiian fish ponds. So that's kind of the first step that the legislature is looking at towards exempting some of those Native Hawaiian cultural practices from SMA review.
Thank you, Maya. So on your screen, you have the proposed amendments to the Planning Commission Rule number 8 resulting from the Joint Planning Commission meeting. Planning Commission Rule 8-10A3, the waiver of the public hearing and action. On your screen before you, we are proposing to remove the provision that will now require all other structures or activities other than structures and activities listed in the Planning Department Rule 11-7 will now need to go before the Planning Commission at a public hearing in order to secure a shoreline setback variance. The next amendment that we're proposing to the Planning Commission Rule 8 is the criteria for the approval of a variance located within Planning Commission Rule 8-11, in which we are removing the word sand. This provision was made to address the concerns raised by the Joint Planning Commission to remove the word sand from beaches under Rule 8-11 D2, the criteria for approval of a variance under the hardship standard. And lastly, the planning director is proposing the amendments to Planning Commission Rule 9, 9-11B4, which is the archaeological resources, which reads A, an archaeological inventory report or assessment prepared by a licensed archaeologist containing significant assessments, effect determinations, and proposed mitigation commitments. The report should be completed pursuant to the Department of Land and Natural Resources State Historic Preservation Division rules. B, a prior no effect letter from the DLNR SHPD for the subject property, or C, a letter and location map for the planning department to submit to DLNR SHPD claiming no significant historic sites are likely to be present. The letter must present supportive evidence documenting the proposed land altering activities, including the affected area and depth of disturbance, and documenting the likely nature and depth of the historic properties that may have once existed in the area. These are what are being proposed. The bracketed and strike through is what we're proposing to remove. And lastly, the planning director recommends that the Joint Planning Commission approve the proposed amendments to the Planning Commission Rule 8 and 9. And again, just to go over the next steps, I know this was discussed last April, but I kind of want to go over it one more time. So for the Planning Commission Rule 8 and 9, the commission can either adopt the rules as recommended by the planning director. The commission can make motions to amend the rules. Once the rules are adopted, the rules will be transmitted to the mayor for review. Once the mayor has signed the rules will be filed with the county clerk's office. The rules will become effective 10 days after they are filed with the county clerk's office. As for the Planning Department Rule 11, the planning director will incorporate the feedback from the Planning Commission. The planning director will hold a community meeting to present Rule 11 and get additional public feedback. And then Rule 11 will then be transmitted to the mayor's office for review. Once the mayor has signed the rules will be filed with the county clerk's office, and the rules will become effective 10 days after they are filed with the county clerk's office. And that concludes my presentation. The chair is yours.
Okay. Thank you, Tracy. Maybe if you could leave the amendments on the screen for us, I think that might be helpful for our discussions purposes. So, commissioners, questions, discussion? Yeah, questions for the staff at this point. Yeah. Oh yeah, I think we can bring them back up, right? Yeah. Yeah, they're on the Zoom. Yeah, Leeward commissioners, any questions for staff at this point?
Yes, aloha. This is Mahina Paishanduart.
Oh, go ahead, Commissioner.
Can you please, thank you. Can you please review for us once more the proposed revision to regarding sand hardening? Can you just provide a little bit more information again? Thank you.
Commissioner Paishan Duarte, is that the discussion within the hardship standards where the private facilities or improvements that may artificially fix the shoreline and how we are
Yes,
moving this
thank you.
on? Okay.
Yes.
Aloha, Commissioner. This is Maya Jackson. So I believe this was a request from the last meeting. Commissioner Vitusik, if I recall correctly, requested that the word sand be removed because the word beaches already, the definition for beaches already contains the word sand. So it was felt that it was a redundant use of the word. So if
Thank
you
you.
refer
I
to
do
the
recall
definition of,
yes. Please proceed. Sorry. Thank you.
yeah, so if you refer to the definition of beaches that's in the rule, you'll see how the beaches are described. Did that answer your question?
Yes, thank you.
Okay. And Chair, if I may speak to some of the testimony that was received.
Yes, go ahead, Maya.
So one of the common concerns was the change from a 20-foot to a 40-foot setback. And the testifiers felt that the 40-foot setback wasn't sufficient. The change was made due to Act 16, just to bring our rules in alignment with the state law. So now the new minimum is 40 foot. The planning director has the authority to set a greater setback on a project by project basis. So that evaluation is done based on the property, based on what information we have on erosion rates for that particular property. And there are times when the director does set a larger setback. Those often don't come before the commission because they're done for homes that are under $500,000 in valuation. So a minor permit is issued. So that's why the commission doesn't typically see those. We do, the department started a shoreline setback project, I think about 2 years ago. And they're working with a consultant and other stakeholders to determine an erosion rate for our county for the various geological typologies around the island, because we are unique. We're very different in our geology from Maui and Kauai and Oahu. That study is ongoing, and once that is completed, Rule 11, which is our shoreline setback rule, will be amended again to incorporate any new setbacks, which we anticipate will probably be increased in some areas and may stay the same in others. But the minimum for the entire state is now 40 feet.
Thank you, Maya. Any questions for staff? Commissioner Duarte?
Thank you. Thank you. Just one final question to staff. Of all the testimonies received, I tried my very best to read every single one of them, but I was not tracking about what percentage, estimated percentage are, I saw the vast majority by my review that are opposing the rule, the amendments to Rule 8 and 9. Do you know, are there any written testimony that came in support or in favor of the proposed amendments? I'm just trying to understand the percentage of opposition as opposed to support.
I believe Ms. Hardin's testimony supported some components and opposed others. And that would be the only one that we're aware of that is somewhat supportive of the rule changes.
Thank you.
Okay, any other commissioners? Okay, for Maya, so based on what you've shared with us, there is a report pending that is looking at here on Hawaii Island, specific areas may or may not need increases or changes in their shoreline setback area. So for like some of the testimony today regarding like Ali'i Drive, that may be like, oh, well, we got to increase it. Or, you know, if we're in Puna area where there's all cliffs, maybe more adjustments because there is no basic like shoreline. But is that what you're basically the idea of what that study is talking about?
Yes. And I would also like to just clarify again that a lot of the testimony that was received was opposing the shoreline setback, which is in the Planning Department Rule 11. And the commission does not have the authority to change or amend that rule. The director just provided it to the commission and the public to see how the department rules related to shorelines and the commission rules interrelate. But the director is going to take public testimony into consideration, gain more testimony when we have the community meeting, and then make the amendments to Planning Department Rule 11.
Mr. Chair, if I may.
Go ahead.
Thank you. Just to add to that, so what we have been working on, just to continue on with what Maya was saying, is that we've been working on science-based shoreline setbacks. It's been in conjunction with the UH, with NASA and our department, as well as a consultant team. And what we're looking at is a kind of again, science-based, so applicable to the situation on the ground or on the shoreline. What we anticipate is certain areas will follow projected sea level rise with an increase of the shoreline setback based on that. We're also looking at a kind of a rise and run potential for steep polys and cliffs, which is kind of unique to our island. And then other areas may not change and keep that 40 where it wouldn't be needed. That's the framework that we're looking at right now, and that will go through an entire public hearing process, et cetera, to be adopted. But it's being based on science is the goal there. So any questions, happy to answer.
What's the time frame on the completion of the study?
We're close. We're pretty much at the final stages of it. Expect to have it coming out probably at the end of this year, beginning of next.
Thank you.
Any other questions, commissioners? Oh, Vice Chair DeFranco.
Getting back to Zooms. Yeah, I just wanted to mention, I appreciate that, reaching in and looking for the Kuleana and how to protect some of the Kuleanas that are in existence. And I did also notice, in looking at a lot of the testimony, which to me was cut and paste and a bit repetitive, but it had the common feeling of, wanting to include more community input and transparency in doing this. But I feel like you've done a good job in trying to, make the changes that we asked last time. And I appreciate that. Thank you.
Thank you. I guess I wanted to also focus on some of the testimony that we got today too. They talked about this Cultural Resource Commission regarding the archaeological studies and that stuff. How does the planning department interact with that commission, if any?
So
Sure. So the CRC, we administer the CRC, or the Cultural Resource Commission. At times, applications are sent through there. We have a couple in there right now. Typically speaking, they go through SHPD. SHPD is the authority of the State Historic Preservation Division. There where we send the request to whether to review an AIS or archaeological inventory survey, or for them to make the determination that no further work is being done there. They are the authority on that. When there is a request by them, or potentially the commission, as there has been, or if we see something unique, we will send that to the CRC for their review. It's not every single time. It's kind of on a case-by-case basis.
Thank you. Commissioners, any other questions, discussions?
Could I ask for some clarification on the waiver of public hearing?
Yes, so what did you want to know about the waiver?
I understood what was in the presentation, but
Mhm.
just how that applies with what we have as far as the rule changes in front of us,
Okay.
because it looks a bit different to me.
So basically the state law allows the planning commission rules or the planning commission to delegate to the director the ability to waive a public hearing for issuing a shoreline setback variance. And they allow that for I believe 3 things. And those are listed on page 8-6 of Planning Commission Rule 8 in section 810. And at the last hearing, one of the commissioners said that one provision that the state law allowed, which was to waive a hearing for other structures or activities, provided that no person or agency requested a public hearing. The commissioner wasn't comfortable with that, and it seemed like the entire commission wasn't, so we removed that from the rules. So now there are only 3 situations where a public hearing can be waived. That is for maintenance, repair, reconstruction, and minor additions or alterations of legal boating, maritime, or water sports recreational facilities that result in little or no interference with natural shoreline processes. So that's one. The second one is for stabilization of shoreline erosion by moving sand entirely on public lands. And then the third instance is for protection of a structure determined by the department to be legally constructed, or a legal structure or public facility, including any facility owned by a public utility that does not fix the shoreline under an emergency authorization issued by the authority. So 2 of those situations specifically affect public lands and facilities. And then the last one is for maintenance, repair, reconstruction of boating facilities, which are oftentimes also public facilities.
Thank you. That answered my question.
And to just go back to the April meeting, I think Maya had stated that we rarely see these instances happen within the planning department.
Yeah, if I may add, this isn't new. This has been in place for how long, Maya? Decades?
Many years.
Many,
yes.
many years.
And just for my clarification, the rules and amendments proposed today and at the last meeting is just to comply with what has changed, right? The Act 16 and HRS that's been passed over the few years. So we're just trying to move into conformity.
Yeah, I would say the first 2 items that Tracy mentioned in her presentation were directly from Act 16 or as a result of Act 16. The third one was somewhat at the request of SHPE because their application submittal requirements have changed over the last 5 to 10 years, and our rules and application are outdated based on the feedback we got from SHPE of how they want to receive applications. So that last slide was to address SHPE's concerns.
And if I may add to that, we did take into account HAR, the rules for SHPE, into that specific section for the archaeological resources. We combined it with our previous wording within the rule.
Thank you. Any other questions? Leeward commissioners, any questions? Okay. If not, then I will entertain a motion on the proposed rules.
I'll put in a motion to adopt these rules. Adopt the amendments, excuse me.
Okay, it's been moved by Commissioner Daniele,
Second.
seconded by Commissioner Deleuze. Any discussion on this motion? Seeing none, roll call vote.
Thank you. Commissioner Baylock,
Um,
Commissioner Cross,
Aye.
Commissioner Parent.
Aye.
My apologies. I was supposed to go Commissioner Daniele first. My apologies. Commissioner Daniele,
Aye.
Commissioner Deleuze,
Aye.
Vice Chair DeFranco,
Aye.
Commissioner Paishan Duarte,
Nay.
and Chair Lynn.
Aye.
The motion doesn't pass.
Yeah. So we do need all commissioners to either agree or disagree on the motion to pass the amendments. So Commissioner Paishan Duarte, if you could kind of give us your thought process and what kind of additional feedback or additional information that we'd like to change or add or ask the staff for. Yeah, or you could make a motion as well to change
Essentially,
the.
I essentially thank you. Essentially, I agree and approve. I am in agreement with the proposed amendments to Rule 8, not to Rule 9. So if this is unbundled, I would, and separated, and there was a vote called for Rule 8 amendments and then Rule 9 amendments, I would vote differently, essentially.
Sure, Commissioner Paishan Duarte, for Rule 9, what would the changes that you would propose to get it to a level that you're comfortable with?
I understand that we are I understand the reasoning behind this, and I'm very appreciative of the our county staff and to all the work that's been done. I understand that it's the reasoning behind the a proposed amendment is to come into compliance, right, with the standing rules. However, I'm not sure. I don't have a proposed solution or amendment to offer at this time. I am not comfortable with waiving public testimony as proposed.
Okay, is there a specific section that you're calling out in Rule 9? Or a specific
Well,
issue?
if you want,
there?
if you'd like to go to recess, I can take a look. And if it's going to be about me trying to, if I need to provide more substantive feedback, then I'm going to request the recess so I can take a look at all the information that's been presented over email.
Okay, I also see that Vice Chair DeFranco has her hand up. Go ahead.
Yes, hi. I just wanted to tell you, I felt we went from a motion on the table there where we could discuss what's happening, and it moved to me way too quickly into to voting on this. I didn't think that we allowed ourselves discussion, and that would be the time that we could share those questions of what was working and what wasn't working, with all of us. Not to be critical, but that's just how I felt. I felt we really didn't discuss amongst each other how how everyone was feeling, what was really happening. So I have to appreciate that Mahina, Commissioner Paishan Duarte, you know, is feeling this way. And I don't like, you know, personally being pressured in any way either to look at things, but I, you know, can understand from listening to all the people that spoke that they were worried about this ability of the planning director to not have, is it public testimony? Commissioner Duarte, was that it? Was that the Rule 9? that you're
Yes.
Yeah.
Yes, correct.
And that was, you know, brought up by a lot of people. And, you know, there's just that sort of feeling of fear of not having the community empowered in making the decisions. But on the other hand, I also heard quite clearly about how there's only a few instances that this actually wouldn't be going to a public hearing. So in most instances, if anything is going to be done in any shoreline SMA places, it is going to have a public hearing and public scrutiny. And it's only in a very minimal sense that the planning director would even ever execute the idea that there wouldn't be a public hearing. At least that's my understanding, but and I'm not sure if we could even at this time discuss this. I'm not sure if I'm still in order, so I just wanted to say this.
Yes, so thank you, Commissioner, our Vice Chair DeFranco. I think at this point, we would need to have another motion on the table to have discussion. And I believe
Okay, I would like to make a motion to have some discussion here amongst all of us to make sure that we're all feeling comfortable with everything. I need a second then, I guess.
Second. Paishan Duarte.
Okay, we have a motion on the table then, do we? Did that
Okay.
happen? Where
yeah,
are
yes,
we?
I heard you, but if you could repeat your motion.
Yeah, my motion is to sort of table where we're at in this process and make a motion to discuss, to move us backwards a little bit to discuss amongst each other. So it isn't resting on someone's vote.
Yeah.
I don't know how you want me to put it. I make a motion to open a discussion before we finish the vote.
Good morning, Chair, Vice Chair DeFranco. This is Sinclair Solis Ferguson, Deputy Corporation Counsel. So I have a few suggestions. What I'm seeing is that Commissioner Paishan Duarte has some further concerns with, I think it's in Rule 8-10, the waiver of public hearing and action. I think that was her concern. So what we can do, I think the best way to satisfy everyone's interest is, it seems like some commissioners have more questions on 8-10. So the previous motion to approve the amendments failed. So we're back at square one. So I think if the commissioners have more questions about that, right now would be the time to ask those questions. And then once the commissioners have finished asking all of their questions of the department regarding that specific section or any other section that any commissioner has questions about, then somebody can make a motion to either approve the amendments or deny the amendments. And then once that's seconded, then the commissioners can discuss the amendments, and then they can make further amendments to the motion. For example, all these amendments are put before the commission today. The commission doesn't have to accept or deny all of them together. They can accept some and deny some. And also the commission can suggest further amendments to the proposed amendments, but if those further amendments substantially alter the amendments as they are right now, we'll have to provide further notice to the public and continue decision-making on those amendments. So right now, I suggest that you guys go back into fact-finding and ask the department to clarify any concerns that you may have.
Thank you. Those were some things I didn't know we had options on, so appreciate that.
Okay, so commissioners, any further questions for staff? Go ahead, Commissioner Paishan Duarte.
Thank you. And thank you to other staff for helping to guide us through this conversation today. Director Kern, if I might ask you, can you please again, how is the proposed amendment to waive public testimony while it's very far and few between instances where this will come into effect? How will this benefit the public? And how will this benefit you as director? And how will this benefit the public?
Chair, can I just say something foundational?
Sure, go ahead.
Some foundational information for everybody. Again, this is Sinclair Solis Ferguson, the Deputy Corporation Counsel for the Joint Planning Commission. Commissioner Paishan Duarte, I just wanted to give you a little bit of the legal structure for 8-10, the waiver of public hearing and action. This is a little bit of background for everybody. So the Hawaii Revised Statute gives the commission the authority to delegate certain powers to the department. And one of the powers is the authority to waive a public hearing in certain specific instances. And so if you look at 8-10, it's A1, 2, and 3. And so 1, 2, and 3 are already in the commission's rules. So there's already that authority has been delegated in the past already. And so the last time we were here, there was another addition to be another power that was delegated, and that was the power for the department to waive a public hearing for any structure or any use. And that was an issue at the last hearing. And I think the department heard the commission's concerns. And so they removed that delegation of authority. So now these 3 delegated authorities are still in the rules. And I think that one of the amendments on number 2 is just to track what was changed in the Hawaii Revised Statute. So as we sit here today, these authorities are already delegated, and the change is just the underlined words in number 2. So I hope that gives you a little bit of background on this amendment, and then I hope that helps everyone, and I'll pass it to Director Kern to address your question.
Yeah. Thank you very much. So the essence of those 3 components are really when there is a need, and they're really based on the public right now. There's also the ability that if a director makes a decision, there's the ability to file an appeal against that as well. So there's an additional layer. But the intent of these are when there's really a true need for that based on that criteria. Otherwise, everything gets sent forward to a public hearing. It's like Sinclair said, this has been in place for a long time. I'm not aware of any abuse of this, but certainly want people to feel comfortable. Yeah, it's for emergencies.
Yeah, I do see hands up on the screen. Commissioners, do you want the staff to continue, or you want a clarification on what was said?
I wanted a clarification from the planning director on to give us an example of when it is used. When is that waiver ever been used? Can you tell us?
I might look in that. Let me just read these real quick. So the commission hereby delegates the authority to waive the public hearing and take action on a variance application for 1, stabilization of shoreline erosion by moving sand entirely on public lands. Go ahead.
If you guys don't mind, I'd like to actually share screen
Mm,
so that everybody can
perfect.
read it. If you can just give us a moment. So Tracy's going to share a screen of what Act 16 proposed. So what you'll see is the existing law, and then the underlying language is what Act 16 added. So then you'll get to see what the existing law has been, what's already been in our rules for several years, and then the change that was done by Act 16. Just to answer the question of how frequent are these, I've been in the department for 16 years, and I have not personally seen a shoreline setback variance waive hearing. And I've worked in SMA probably about 4 or 5 of those years. So they're very infrequent.
You can't really give us an example of when they would do something like that. What would prompt them to do that?
Sure. Let's
You've
say,
never seen it done.
let's say that there's yeah, I mean, be an example. Yeah, hurricane, cliffs starting to completely erode and fall into the ocean where there needs to be an emergency situation occurring.
Okay, so it's like that. It's like an emergency situation would be, because you have to act right now, that it wouldn't be put out there to the public. And
Correct. I mean, I just want to make a statement. It's a little bit I would say challenging in a polite way, that there's basically an insinuation that the department doesn't honor the public hearing process. For example, we're not required to host Zoom. It's not a requirement. That is a choice that we make as a department to make sure that we have public participation in there. We always err on the side of public participation and public engagement. Other counties don't necessarily do that same thing. We do. We continue to do it.
I personally feel that you do.
Thank you.
That I think you guys are doing a great job, and I know that you're trying to be inclusive, and I appreciate you taking the time to explain it. But because we had so many questions also from people writing in and on Zoom, I am just taking this moment to explore it further so they can hear this from you, because I also felt like that, like you're feeling. So
Thank you, Chair.
Vice Chair.
Vice Chair and Chair LPC and Vice Chair for right now. Thank you.
Hey, Maya.
There is also a requirement that the department provide public and private notice, including reasonable notice to the abutting property owners prior to making a decision on a shoreline setback variance outside of a public hearing. The director also has to follow all of the criteria for issuing a variance. So there is a set strict standards for issuing a shoreline setback variance. And he issues a determination of how the request meets those standards, and that's a public determination that can be appealed then to the Board of Appeals. So there are, there are protections for the public and also opportunity for the public to be notified of what's occurring.
Yeah, this is Commissioner Daniele. Yeah, I'd just like to add that it's curious that no one can remember when this has been used. So I think that's a good testament to the process. Thank you.
So I think it might be helpful to go through, thanks for putting those up on the screen. But let's just go through those again. 1, stabilization of shoreline erosion by moving sand entirely on public lands. 2, protection of a structure determined by the department to be legally constructed, a legal structure or public facility, including any facility owned by a public utility that is regulated pursuant to Chapter 269 HRS that does not fix the shoreline under an emergency authorization issued by the authority, provided that the structure or public facility is at risk of immediate damage from the shoreline erosion as determined by the department in consultation with appropriate agencies, i.e. U.S. Army Corps of Engineers, DPW, and the authorization does not exceed 3 years. And maintenance, repair, reconstruction, and minor additions or alterations of legal boating, maritime, or water sports recreation facilities that result in little or no interference with natural shoreline processes. To me, all three of these are legitimate areas to have that ability to move forward if it's necessary. And again, it's been something that's been on the books for many, many years.
Okay, I don't see Commissioner Paishon Duarte's camera, but did you have any further questions for staff or Director Kern regarding the specific rule?
No further question, just comment. Just, you know, because we don't have a lot of examples for which this rule has been, it has been in practice and it hasn't been applied. For me, that can be looked at two ways. One, that can be positive, and it can also not be positive in the sense that it has not yet been fully applied. These rules have not, well, it hasn't been tested, right? An interpretation in a real case scenario. So I'm not, yeah. So I still have questions regarding Rule 8-10. Rule 810-10. All the other proposed amendments, I don't have a problem with. I think it makes sense. I just want to state clearly where I'm at.
Yeah. So, Commissioner Paishon Duarte, I guess if there's several options that I guess we could go here is one, you could propose further language to strengthen, you know, what you feel needs to be strengthened in this rule, or we can, you know, further have a discussion on the questions that you may have regarding this particular section. So like, you know, because it hasn't been implemented, then, you know, we can propose language to make it very clear on here is exactly when it does apply. So we have several options. So I just wanted to, you know, place that out there.
Thank you. And I understand that you folks have your regular Windward Commission meeting, and I will need to get off by 10:45. What I am proposing is, if it's possible, if this rule amendment to Rule 8-10 be tabled or omitted completely. And if we can schedule, I don't know, another commission meeting to you know, and have a little bit more time to put something forward. I worry that we don't have enough time to come up with an amendment that will maybe strengthen the language. Yeah, that's
Okay.
what I wanted to.
Understood. So
Can I make a quick comment?
Yeah, go ahead.
With respect on this, just want to, it's very challenging for the staff to coordinate joint meetings. It really is. If a bifurcation does happen, that's perfectly fine. I do want to point out that these have been in place and have been in everybody's computers for quite a while. And I would really appreciate some constructive feedback to move us in a direction of some type of certainty so we actually know where we're going on this.
I just wanted to thank the department when I asked for a clarification earlier. I think part of the confusion when I read through it was that I read section or D and E as separate from A. So if there's a way, like, I mean, now reading it after clarification, I understand it a lot better. So maybe that's part of what the other commissioners trying to address here in 8-10.
Commissioner Baylog, you're speaking to section D and E of 8-10.
Yes.
Okay, let me look at that.
I don't have a problem with A. I think it's perfectly clear. I just wanted to add, I think D actually does address the 3 requirements that are stipulated in A. So I
Yeah.
think, I don't know, I'm trying to help.
So, yeah, so section D is basically saying that the department may waive a public hearing and take action on a variance for those items in section A, provided public and private notice is provided and notice to abutting property owners. And then section E is saying that the director has to make that decision to grant a variance based on the criteria in the rule and provide a record of that determination. So going back to the main discussion, I think it would be the department's preference to move ahead as much of the rule adoption as possible. And if the commission doesn't feel comfortable with 8-10, we table that and we will tackle that in the future, along with other recent changes to state law.
Okay, because earlier what we talked about, there's more rule changes coming anyways. So I guess we have to change this motion up again. Sinclair, we have to
So
make a
Chair,
motion.
we can make a motion to amendment 8 and 9 with the exception of 8-10
Yeah,
be approved. So I make that motion.
specifically about 8-10 waiver of public hearing and action.
Yeah, I thought it'd be easier to make the motion that we move to approve amendments 8 and 9 with the exception of 8-10.
Mhm. In its entirety.
Which would in entirety. Motion made.
Second.
Okay, second, okay, motion by Commissioner Deleuze, second by Commissioner Paishan Duarte. Is there any discussion on this motion? To clarify, we are moving ahead with the amendments that were proposed in Rule 8 and 9, except for the section of 8-10 in its entirety, which will be tabled for a later hearing. Okay. If that is understood, then roll call vote. Yeah, there's no further discussion, so yeah.
Commissioner Deleuze,
Aye.
Commissioner Paishan Duarte,
Aye.
Commissioner Baylock,
Aye.
Commissioner Cross,
Aye.
Commissioner Daniele,
Aye.
Commissioner Perrin,
Aye.
Vice Chair DeFranco,
Aye.
and Chair Lynn.
Aye.
The motion passes 8-0. Thank you.
Okay, thank you. Thank you, Leeward Commissioners, for participating today. And I do want to ask the planning department, please keep us posted on Rule 11 with the shoreline setback. I think that's going to be a very hot issue, and we'd like to know what that result is of, when the public hearings are, and how we can participate as well. Oh, sure. Yeah. And Commissioner Paishan Duarte, feel free to reach out to Sinclair if you need any further clarification on the interpretation of that section.
Thank you very much.
Okay. Thank you very much. Move to adjourn joint planning commission hearing. Motion.
I'll make that motion to adjourn the joint meeting of Windward and Leeward Commissions.
Okay. Moved by Commissioner Daniele.
Second.
Second by Commissioner Perrin. All in favor, please say aye.
Aye.
Any opposed? Okay, joint commission hearing is now concluded at 10:37. Thank you very much.